Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and good day to everyone. My name is Hanis binti Wahid and I will be presenting a paper with the title Vicarious Liability in E-Hailing Services, Evaluating Platforms' Legal Responsibility for Driver's Negligence. So this presentation is for the conference, yeah? Okay, the first thing is that for the introduction part, e-hailing or what we call electronic hailing, it is a service that allows customers to hire a vehicle by ordering through platforms, through e-hailing apps on their own smartphones. And in e-hailing, Grab or Foodpanda and everything, they have become very popular in Malaysia because of its convenience, because of its affordability, and as well as efficiency. And this use of platforms here in Malaysia, it becomes more popular after the, especially after the COVID-19 pandemic happened in Malaysia. In fact, in the whole world, yeah. And then, if you look at here, next one, okay. So the development of e-hailing in Malaysia, it begins in the early year 2010s with the introduction of various hailing applications such as Grab, or previously known as MyTaxi, and also later Uber. And the government initially, they face resistance from all the traditional taxi drivers because the taxi drivers, they claim that there will be there were unfair advantages given to in Malaysia. This service also ended to include various options beyond car rides. So it includes e-hailing for bikes and also even for food delivery, especially like what I've mentioned, especially during after the COVID-19 pandemic. And then relating to this paper actually focusing on legal questions relating to liability for accidents cases that caused by e-hailing drivers. So we know that in Malaysia, generally, employer is vicariously liable for the negligent act of their employees who committed which has been committed during the course of employment. But the problem is in e-hailing, yeah, drivers, they are often classified as independent contractor. In fact, all the platforms, they usually try to disclaim liability of independent contractors. And the law is that employers, they will not be vicariously liable for any negligent act committed by independent contractors. So in Malaysia, there is no case law that provide clear rulings or clear law on whether these hailing platforms, the ride hailing platforms like Uber, like GrabCar, whether they are liable for passengers' injuries. Okay. In other words, whether the drivers are independent contractor or employee. Yeah. And there is one case where the court, they ruled that drivers are independent contractor. But this decision actually is made after looking at the, what we call at the facts and circumstances of the case itself. So this caused uncertainty for victims, insurers, and also companies. And this actually might be bad for victims who suffer injuries because of the accident. Because they can only claim against the driver and the driver's insurance provider. And they cannot claim against the e-hailing platforms. So yes, in fact, they will get compensation. Yes, they will get compensation, but the amount itself, it might be lower, especially if the driver itself is underinsured. And because e-hailing companies like Grab and everything, they have far greater financial resources than individual drivers. Another point is that it is unfair if the e-hailing platforms, deny their liability, because yes, it is true that the negligence is committed by the driver, not by the platforms. However, it is still done, the action itself, the negligent act itself is still done during the course of working, during the course of driving the vehicle. And the platforms also, they actually get financial benefits from the work done by the driver. So it will be unfair for them to disclaim any liability in case of any accident happen. So therefore, this paper, the aim of this paper is actually to examine the application of vicarious liability to the... Okay, hold on. Let me share the slide again. Okay. All right. Okay, now, the third one is, okay, if we look at the third one, the third position, okay, now we will looking at the discussion relating to the law of vicarious liability in Malaysia. So basically, vicarious liability, it is a legal principle that makes an employer liable for the wrongful act or negligence committed by the employee. But it must be done within the scope of employment, during the course of employment. So this doctrine is actually derived from common law doctrine, yeah. And in order for, under the common law, in order for an employer to be vicariously liable, there should be three elements fulfilled. Number one, there should be existence of a special relationship between parties. Number two, there must be tort committed by the employee. And number three, the tort itself, it must be committed during the course of employment. Okay, so for the first requirement, look at the existence of the special relationship between parties. Meaning between the defendant and also the tortfeasor, i.e. the person who commits the tort itself. For example, if the tortfeasor is the employee of the defendant, so in this case, there is a relationship as an employer and employee between both parties. So as I mentioned, it can also be other special relationships such as between principal and agent, yeah, and etc. So in this situation, the relationship, it must be between the e-hailing driver and also the platforms. So the plaintiff, usually the person who suffered injuries because of the negligence on the part of the driver, must prove to the court that there is actually special relationship exists between the driver who act negligently and caused the injuries to the plaintiff, as well as the platforms. Specifically, it means that the plaintiff here must prove that there's a relationship of employer and employee between the drivers and also the platform. Yeah, okay, that is the first requirement is there must be wrongful act. There must be tort happen committed by the driver. Yeah. So the thing that the court will determine whether there is any wrongful act committed before they can impose any liability on the part of the platform. So the tort related in this discussion, relating to my discussion, it will be negligence. Negligence, yeah. When we talk about negligence, it means it happens when a person owes a duty of care towards another person, and that person breached that duty of care by acting contrary to the standard of care required of him, and because of that breach, it caused injury to another party. Okay, so here in this situation, the plaintiff, in order to prove that there is negligence on the part of the driver, the plaintiff needs to prove the existence of a duty of care, number one. Number two, must prove there is breach of that duty of care. And number three, must prove causation. Okay, this need to be proven by the plaintiff, i.e. by the person who suffered injuries because of the negligence on the part of the driver. Okay. Lastly, after proving that there is special relationship between the driver and also the platforms, and then after proving that there is tort, i.e. negligence committed by the driver, the third requirement is that what we call the driver, the victim needs to prove to the court the element of within the course of employment. So it means that the employee committed the tort, the employee, i.e. The employee, he must committed the tort when he's doing his work. It must be within the course of employment. And the tort is said to be within the course of employment if, number one, it is either expressly or impliedly allowed by the employer, number one. Number two, when the employee does something that is authorized in an unauthorized manner. That is number two, the second situation. One, the thought is said, we can say that the thought is done during the course of employment is one. Number three, when the employee does something that is closely connected to what he is employed to do. So this, if it falls under any one of the situation, then we can say that the thought happened during the course of employment. Okay. All right. Next one is the analysis about the liability of e-hailing drivers and platforms. Yeah. Like what I've mentioned just now, but the problem is all these e-hailing platforms such as Uber and etc., they always deny their liability by saying that the drivers, they are merely an independent contractor, not an employee. So because of that, they said that they will not be vicariously liable for any negligent act committed by the drivers. Okay, because it needs to fulfill the three requirements before. So it doesn't fulfill the three requirements before. That's why they said that they are not liable. They are not liable for any negligent act committed by the driver. Okay, but the position if you look at the position in UK, the position is different, yeah, because there is one case, the case of Uber BV, where in this case, the Supreme Court in this case, they uphold the lower court's decision that said the Uber drivers were actually workers, not independent contractors. So they are entitled, because they are workers, they are entitled to paid leave, they are entitled to minimum wages and also other legal protection. So that's the position in the UK. But we compare it with other country as well. We compare the position in New Zealand, for example. The position is quite similar with the position in Malaysia. Because there's one case in New Zealand where the court held that Uber drivers are independent contractors, not workers. But the court made that decision after looking at the facts and circumstances of that case. And then the court said that after looking at the facts and circumstances, everything, the court said that the evidence shows that the claimant in that case, the intention of that claimant in that case was actually to operate the business independently, not influenced by the platforms. So that's why the court in that case held that the drivers in that case was an independent contractor. Okay, that is the case in New Zealand. In Malaysia, the position is actually still not in favor of drivers because like what I've mentioned, e-hailing platforms in Malaysia, they classify their drivers as independent contractor. And they said that the reason why they said that the drivers are independent contractor, because they said that there's element of flexibility in their working hours, yeah? Or they said that the car itself, the ownership of the car itself, not owned by the platform, but owned by the driver, for example. So there's one case in Malaysia, which is the case of Law Guat Chin. Yeah, this case of Law Guat Chin decided in the year 2022, where in this case, the court held that e-hailing driver is not an employee, but it's not an employee because they do not fall under section 2 of the Industrial Relation Act. Okay, and the court listed different reasons, yeah, a few reasons in this case, because the court, after looking at the facts of the case, the court said that in this case, the third respondent in this case, which was the platform, did not prepare any income statement, and then did not control the applicant and everything. So that's why the court said that the driver in this case was considered as independent contractor, not an employee, and not fall under the definition of employee itself. So if you look at here, now it means that the e-hailing drivers in Malaysia, they are not deemed as employees or workers under the Employment Act. Okay, making them, because of that, they are not entitled to the same benefits and protection as other conventional workers, conventional employees. So there are discussions made to make the e-hailing platforms vicariously liable for their drivers, yeah, because actually because this platform, they have operational control, and they also gain financial benefits from the work done by the drivers. So there are few suggestions made, for example, to amend the definition of employer and employee as stated in the Employment Act to include the e-hailing drivers. So some suggest to include e-hailing drivers as employee under the definition of employee as stated under Employment Act. And also there's also another suggestion made by the Malaysian Bar Council that said that there should be a reform in the law to clarify the position of e-hailing drivers, their employment status itself. So they want to make clarification about the status of these drivers that registered in the platforms. Some said, some suggest to include gig workers, this is a bill that provides about social protection, about the definition of gig workers, and also detail about the compensation, about the grieving mechanism and everything. Yeah? Because this bill, actually it will be tabled in Parliament this June 2025. Yeah. So maybe clarification about the definition and the status of these drivers who work for the who registered under the platform. Maybe they are what we call. Hold on, I'm sorry. I will share the content again. Okay, hold on, yeah. Okay. Maybe their status can be clarified in this proposed bill. Okay, so those are some of the suggestions made in order to clarify whether drivers who registered under the platform, e-hailing drivers, whether they can be considered as employee or independent contractors. So in conclusion, okay, as a conclusion for this, in Malaysia, we don't have many cases that confirm the position of e-hailing drivers. There's no cases that can confirm whether the e-hailing platforms will be vicariously liable for negligence done by their drivers. But we can say that in order to determine this point, the court will still refer to the common law, which is the court will refer to the three elements or the three requirements needed. For example, which is number one, the court must look at the existence of a special relationship between parties. Number two, there must be tort committed. And number three, it must be done during the course of employment. But the problem is in proving the existence of a special relationship between the parties, i.e. between the driver and also the e-hailing platforms. So it is important for us to clear the issue in order to safeguard or to protect the victim's right, i.e. the plaintiff's right, and also to protect the right of e-hailing drivers. Okay, and this can be done by that clarify this position. So it will be easier for the court to decide instead of having different judgment for different case by looking at different facts and circumstances. Instead of having that problem, there should be one law that clearly state whether the drivers, the e-hailing drivers, whether they can be considered as an employee or independent contractors. So this can only be done by, number one, as I've mentioned just now, by amending the definition of e-hailing drivers to be included as an employee under the Employment Act 1955, or also having another specific law, for example, like the gig workers bill, to determine the position of these drivers. So with that, I end the presentation for this conference. Thank you so much for listening. Assalamualaikum warahmatullahi wabarakatuh, and have a good day. Thank you so much.